Good morning. We're glad that you've joined us today for Cappella at Reformed Evangelical Seminary. My name is CJ Bowen, Director of Student Development here at the seminary, and these are monthly Cappella meetings, serve as the seminary's chapel service, giving us time to meet together for prayer, for instruction, and conversation on important topics concerning Christian life and doctrine. Our speaker today will be Jeff Shafer, an attorney who served as senior counsel for many years with Alliance Defending Freedom and is now the director of the Hale Institute at New St. Andrews College. Hale Institute's primary goal is to advance public understanding of our common law heritage, American constitutionalism, and precepts of law vital to a just social order from the perspective of the Reformed tradition of the Christian faith. We look forward to hearing from Mr. Shafer in a few moments as he speaks to how the law relates to issues of killing and death, especially in light of significant legal changes in recent years. But before we get to that, let's begin with an opening prayer that voices a Christian perspective on death from the 17th century English poet priest John Donne. And I've asked Matt Daly to lead us in this prayer.
The hour of my transmigration. O eternal and most gracious God, who having consecrated our living bodies to thine own Spirit and made us temples of the Holy Ghost, dost also require a respect to be given to these temples, even when the priest is gone out of them, to these bodies when the soul is departed from them. I bless and glorify thy name, that as thou takest care in our life of every hair of our head, so dost thou also of every grain of our ashes after our death. Neither dost thou only do good to us all in life and death, but also wouldst have us do good to one another, as in a holy life. So in those things which accompany our death. Let this prayer, therefore, O my God, be as my last gasp, my expiring, my dying in thee, that if this be the hour of my transmigration, I may die the death of a sinner, drowned in my sins, in the blood of thy Son, and if I live longer, yet I may now die the death of the righteous, die to sin, which death is a resurrection to new life. Thou killest and thou givest life. Whichsoever comes, it comes from thee. Which way soever it comes, let me come to thee. Amen.
Amen. Thank you, Matt. That's a beautiful prayer, part of Donne's Devotions Upon Emergent Occasions, written when he was in extreme sickness and suffering himself. And the two things that stood out to me about that prayer, one, his view of the consecration or the importance of the body as well as of the soul, and then our responsibility to one another in death, not simply taking account of our own passing, but the very idea of death, what it means as part of the Christian community, our responsibility to one another. For our scripture reading this morning, we turn now to the poetry of Job, as Job likewise meditates on death and the hope of renewal beyond death. And I've asked Bryce Tyler to read for us this morning. Bryce, you're still on mute for us.
Sorry about that. John 14, 1 through 15. Man who is born of a woman is few of days and full of trouble. He comes out like a flower and withers. He flees like a shadow and continues not. And do you open your eyes on such a one and bring me into judgment with you? Who can bring a clean thing out of an unclean? There is not one. Since his days are determined and the number of his months is with you, and you have appointed his limits that he cannot pass, look away from him and leave him alone, that he may enjoy like a hired hand his day. For there is hope for a tree, if it be cut down, that it will sprout again, and that its shoots will not cease. Though its root grow old in the earth, and its stump die in the soil, yet at the scent of water it will bud and put out branches like a young plant. But a man dies and is laid low. Man breathes his last, and where is he? As waters fail from a lake, and a river wastes away and dries up, so a man lies down and rises not again. Till the heavens are no more, he will not awake or be roused out of his sleep. Oh, that you would hide me in Sheol, that you would conceal me until your wrath be past, that you would appoint me a set time and remember me. If a man dies, shall he live again? All the days of my service I would wait till my renewal should come. You would call and I would answer you. You would long for the work of your hands.
Amen. Thank you, Bryce. So, as we continue on this theme of death and dying, as well as the law, take another moment here in a moment to hear the troubled poet Sylvia Plath reflect on death in her poem, Two Views of a Cadaver Room. In this poem, she's going to set out two scenes involving death. One, a window into a modern dissecting room, and two, the chaotic scene from Bruegel's painting The Triumph of Death, which appeared as our title slide today. These two scenes depict human beings interacting with death in very different ways, reflecting not just different approaches to death itself, but different ways of thinking about what human beings are and what they might be for. And so, as a bridge to our presentation today, I want us to ask what effects there might be when humans come to be viewed primarily as objects for experimentation, for acquiring medical information, which will then lead to progress, technological progress, medical progress, obviously good things. But when they are abstracted or severed from considering humans as creatures made in the image of God with a particular nature, and a particular telos, an eschatological end in view, when those things are separated, what happens to a culture and a people, especially when those people who have adopted this newer view start to make our laws? And so with that in mind, listen as I read Sylvia Plath's Two Views of a Cadaver Room. The day she visited the dissecting room, they had 4 men laid out, black as burnt turkey, already half unstrung. A vinegary fume of the death vats clung to them. The white-smocked boys started working. The head of his cadaver had caved in, and she could scarcely make out anything in that rubble of skull plates and old leather. A sallow piece of string held it together. In their jars, the snail-nosed babies moon and glow. He hands her the cut-out heart like a cracked heirloom. In Bruegel's panorama of smoke and slaughter, 2 people only are blind to the carrion army. He, afloat in the sea of her blue satin skirts, sings in the direction of her bare shoulder, while she bends, finger a leaflet of music over him. Both of them deaf to the fiddle in the hands of the death's head shadowing their song. These Flemish lovers flourish, not for long. Yet desolation, stalled in paint, spares the little country, foolish, delicate, in the lower right-hand corner. Today, for our presentation, we're glad to welcome Jeff Shafer to Cappella as our featured speaker. Mr. Shafer is the director of the Hale Center at New St. Andrews College, where he teaches courses and convenes symposia and develops academic and advocacy initiatives on matters of policy concern that relate to the common law heritage of the United States in the face of a rapidly shifting legal landscape. Before coming to the Hale Institute, Mr. Shafer served as senior counsel with Alliance Defending Freedom and has litigated public interest cases in federal and state trial and appellate courts. Over on the Hale Institute's YouTube page, you can find a number of his presentations on topics such as the common law tradition, immigration, the legal implications of the transgender movement. And today he'll be presenting for us on the topic of death and of the law. So, Jeff Shafer, welcome to Cappella. We look forward to hearing from you now.
Good morning. Are you able to hear me? Am I coming through from this end?
Yes, sir.
Yes.
Okay. All right. Well, in that case, I'll begin. Thank you for this opportunity to speak with you. Upon learning recently of your seminary studies this term, that it included matters of death and dying, I thought I would take the opportunity to discuss a few among a much larger number of the law's engagements with matters of life and death. There's an important sense in which we could say that the law's approach to the questions of human life is a question about the law itself. When the prohibition on murder becomes a negotiable rule in a series of contexts, with the matter settled by standards of utility, this, in principle, evacuates law of its authority. The moral truth of life is exchanged for calibrations of balance in interest, of preference, or other aims of those possessing power. But as you know, well, in most places in the country, the criminal laws against shooting your neighbor remain reliably enforced. The law's broader commitments to life are fraying, particularly because of the expansion of the categories of permissible killing. One familiar example that's illustrative and normatively momentous, of course, is abortion, which, though being a radically antisocial and profoundly barbaric practice, is conduct that most states today continue to permit without legal penalty, even after the Supreme Court's Dobbs ruling that it reversed Roe versus Wade. Indeed, many of these state governments positively celebrate, promote, subsidize this form of killing. We'll look at this a bit more later. But there are a number of other forms of legally cherished and facilitated avenues for killing, varying somewhat among jurisdictions, as we'll consider. My aim for my comments today is to run through a series of observations on this field, seriatim. That is not so much intending a seamless flow, but rather a sequence of stops at points of interest implicating the life and death questions. Before getting to all of that, and by way of a segue into the discussion to come, a brief word here on a scene having quite some pathos in the film Sophie Scholl. Perhaps some of you have seen it. Story of the young students in the White Rose. Near the end of the film, in which are present the three White Rose protagonists and their friend, after they had been convicted and sentenced to an immediate death for distributing publications criticizing the Fuhrer and the Third Reich. The three were permitted to be together momentarily in a prison anteroom of sorts, from which they will be led to their execution. And this brief scene, as they gather for the last time, knowing that they are but minutes away from their deaths, is, I think, the most poignant in the film. Apart from a short sentence that's whispered by only one of them, they are silent, though communicating immensities through a knowing gaze and then an embrace. Their circumstances, they confront with wits about them the mystery and the gravity in being but a moment from the end of physical life, standing on the very threshold of eternity and existence. This singular condition eludes the containing effort of words. They approach, to paraphrase St. Augustine, the very violence with which the body and soul are wrenched asunder. Condition of death this way. The continued barring an intervention of divine omnipotence, lasts as long as and upon us. She offers prayers as her death approaches. The prison and life eternal. By all of these, the film narratively enacts an acknowledgement, permitting the viewer to join in awareness, is not oblivion. I offer these comments in order to contrast the profundity of our subject of consideration today with the deprived assets of contemporary law, which I'd like to explain, in certain measure has fled the majesty of its calling by fleeing also the resources for capably fulfilling it. Our procedural republic, as Michael Sandel has aptly designated it, with its voluntarily stripped down metaphysical possession, has retained the temerity, but not the aptitude to approach country has for many decades bound its deprived, hollow resources and utilitarian calculus in the company of the weighty objects of its attentions and ministrations, questions like life and death. As one illustration of the court's flight from theological resource, we might consider the Supreme Court's 1980 decision in Harris versus McRae, involving a challenge to the Hyde Amendment. That's the prohibition on federal funding of abortions through Medicaid. The plaintiffs bringing that lawsuit had alleged that this abortion funding clause, recall that provision reads, Congress shall make no law respecting an establishment of religion. Argued that the funding restriction there was a First Amendment violation because it, that is the Hyde Amendment, incorporates into law the doctrines of the Roman Catholic Church concerning the sinfulness of abortion, rejected the plaintiff's legal claim about the Hyde Amendment. The court did accept their premise, namely that it is unconstitutional to have so-called religion. The court offered an analogy. The court wrote that the fact that the Judeo-Christian religion state or the federal government may not, consistent with the Establishment Clause, enact laws prohibiting larceny. That is to say, the fact that a moral precept is found within both American law and in theology does not mean that the law is relying on theology. It can be a mere coincidence. And when that is so, the law under consideration remains valid, rather than being poisoned and illegitimate, as it would be if it indeed had been grounded theologically. Almost 2 decades earlier, the Supreme Court in the case of McGowan versus Maryland had made the same point, asserting that does not ban to coincide with in the McGowan Sunday closing law. While Sunday closing laws obviously in their origins had a religious motivation, the law in this case escaped the court's rebuke because that original religiousness had dissipated through time to the point that the contemporary motive for Sunday closing laws is that resting one day in 7 is, wrote the court, founded in experience and sustained by science. So back to the Supreme Court's ruling in Harris versus McRae. The court wrote as to the abortion funding prohibition the following: the Hyde Amendment is as much a reflection of traditionalist values toward abortion as it is an embodiment of the view of any particular religion. The statute for that reason survived the judicial gauntlet, and so it goes, you see. So our legal possession at the moment is something of a bricolage composed of contemporary agnostic sentimentality combined with those laws and traditions surviving from ancient days when their theologically grounded truths were not just authorized, but known to be necessary and proper features of jurisprudential and public reason. In a famous early 19th century case from the Court of Appeals in New York, Chancellor Kent had described how the very idea of jurisprudence, with all of the ancient lawgivers and philosophers, embraced the religion of the country. Since the 20th century, by contrast, we've renounced that ancient practice and acknowledgement. All of this to the effect of our own perplexing, I'd like to suggest. Well, with that description of our analytical handicap, let's turn here to look at the issue of so-called assisted suicide. It has been a prominent matter of discussion recently in the UK, whose parliament not long ago voted in favor of so-called medical aid in dying for terminal patients. And I understand in the last few days, we're offering refining amendments to that legislation, which now awaits royal approval before coming into force, which may be quite some time. And of course, in Canada, which since 2016 has had a booming suicide industry, after its legislature complied with a Supreme Court ruling that announced that the availability of this kind of killing is required by the Canadian Charter, in furtherance of, and I'm not making this up, the right to life. Euthanasia by doctor is now accounting for around 4% of Canadian deaths, and as high as 7% of deaths in certain jurisdictions. And closer to home, there's a number of states in the US that now permit you to invite a doctor to kill you and for that doctor to do so. I will skip the elaboration of the centuries of English common law condemnation of suicide as well as its enablers. The common law commitment received with some modification on these shores as well. And instead, I'll just bring us up to a US Supreme Court decision on euthanasia from 1997. The case is Washington versus Glucksberg, in which the court famously depended on our long and uniform legal tradition for its resolution. The court rejected a claim brought by physicians and others asserting a constitutional right to so-called physician-assisted suicide. The court's examination revealed that for over 700 years, the Anglo-American common law tradition has punished or otherwise disapproved of both suicide and assisting suicide, and that criminal prohibitions on assisting suicide persist in most states. Thus, it is not a fundamental liberty interest protected by the Due Process Clause, the 14th Amendment. So the court invoked tradition to resolve this question. The court had reviewed the legal history to show that colonial and early state legislatures and courts did not retreat from prohibiting assisting suicide. As the right to life at common law was sacred and inalienable, the prohibitions against assisting suicide never contained exceptions for those who were near death, be the person one who is hopelessly diseased or fatally wounded, even prisoners who are scheduled shortly to be executed. All were, as any other person, equally protected by the law's prohibition on their killing. Indeed, an advisor to a suicide was guilty of murder under our historic law, and that the consent of a homicide victim is wholly immaterial to the guilt of the person who caused his death. So went the discussion in the Supreme Court's decision in Glucksberg. Yet, as I mentioned, today, multiple states, as well as the District of Columbia, now permit physicians to euthanize their patients at their request, with multiple additional states considering proposals for that policy. How so? What of the Supreme Court's Glucksberg ruling that described how this was treated for centuries as murder in our legal system? We'll come to find that the court in that case merely explained that the force of customary law indicates that it is permissible for states to criminalize assisted suicide, that the Constitution does not forbid such legislative prohibition, that there are rational and persuasive arguments for the continuation of that prohibition. But the court did not rule that killing a person at his request is inherently criminal, a violation of justice, and an affront to law or to our legal system. Indeed, the court majority concludes its Glucksberg case opinion in a form to which we have become sadly accustomed by celebrating the open society that leaves even questions of life and death for resolution by selection through democratic process. I quote the court here that wrote, "Throughout the nation, Americans are engaged in an earnest and profound debate about the morality, legality, and practicality of physician-assisted suicide. Our holding permits this debate to continue as it should in a democratic society." End quote. As it should. This is the operation of the procedural republic that I had mentioned earlier. That is, we're ruled by agnostic procedures, feigning to lead the substantive claims of justice on such small matters as life and death to the fluctuations of majority consensus, or when not otherwise prohibited, left to individual selection in their exercise of rights. Well, that being said, what of a legal regime that makes the request or consent to murder by physician a permissible choice? What has the law done to the dignity of a person and to the law itself when making life itself a selection? We might pause to consider this for a moment. The philosopher David Velleman, for one, has reflected on the disruptive dynamic that is engaged by replacing unchosen defaults with choices. Granting persons a choice to keep or reject what had been the status quo does not simply add a possibility. It eliminates the former environment and its benefits that are dependent on the unchosenness of that condition. While living with the unchosen status quo may have been best for a person, choosing the status quo may be the worst. Velleman offers a prosaic illustration of this dynamic. He writes, "If I invite you to a dinner party, I leave you the possibility of choosing to come or choosing to stay away, but I deprive you of something that you otherwise would have had, namely, the possibility of being absent from my table by default, as you are on all other evenings. Refusing to attend a party is a different outcome from not attending without having to refuse. Having choices can thus deprive one of desirable outcomes whose desirability depends on their being unchosen." End quote. So in considering the law authorizing a person to choose to be euthanized, Velleman points out the harm to patients in denying them the possibility of staying alive by default. The concern here is not just with the person having the choice, but in what having that choice means to other people and for the social and conceptual dynamics of life and death. And Velleman writes, I quote him again, "Once a person is given the choice between life and death, he will rightly be perceived as the agent of his own survival, whereas his existence is ordinarily viewed as a given for him, as a fixed condition with which he must cope. Formally offering him the option of euthanasia will cause his existence thereafter to be viewed as his doing." End quote. So when a person's continued existence is not the default, but simply his selection, it should not then be surprising that other people then can and will demand to know why he has made the choice to stay alive, and then to critically evaluate those reasons from a vantage that assigns no presumption of life's givenness or value. So here we might pause to observe that when life is merely a choice, it is no longer life as we have ever known it. And once it is reduced to an individual option, rather than life being a radically unchoosable context of givenness, the person's decision or choice on life or anything else merits no deference or priority, really. Life cannot be both the morally privileged context from which and within which honored choices are made, and itself be but one more choice. As Velleman more or less puts it, a person's choices wouldn't matter unless he matters. That is, unless his life itself is not a choice, but a normative condition that grounds our respect for his decisions. It is by this dislocating dynamic of choice that we can understand why regimes of voluntary euthanasia tend to develop into regimes of involuntary euthanasia. The path from the choice to die to the duty to die makes a fairly straight line. A person's so-called freedom to choose death has freed up the state's choice about his death too. Accordingly, the legal choice against or for life is one that the law can offer only deceptively. Life, in fact, is available only when the state approves it, not because your choice merits deference. Once your life moves from default condition to subjective choice, neither life nor choice any longer has heft or an objective claim to honor. And of course, all of this has systemic consequences. A point of interest to me, one that the US Supreme Court in the Glucksberg case recognized as among the unquestionably important and legitimate government interests, is that of refusing legal standards whose operation could compromise the integrity or enforcement of values that the government otherwise prizes and wishes to retain. Indeed, through its euthanasia authorization, the law offers the notion of better off dead, not just to persons in vulnerable condition and to the community around them, but back upon the law itself. The law's systemic unity entails that inviting into its precepts a disposition of favor toward killing, especially of the old, the feeble, the dependent, will require an internal face-off with those obviously incompatible features of law that, for instance, view murder as the epitome crime, or that view persons' weakness and vulnerability as invitations to particular legal solicitude and protection, you see. All right, well, having said all of that, maybe we would turn to consider this long-running nihilism of the United States abortion regime. In this context as well, an element of our contemporary American rights-based conception within liberal legal theory feigns to leave the question of what a person is up to each individual to resolve for himself, whose free efforts in that regard the state purportedly exists to guard and enable. But of course, when the court is acting this way all along, it's carrying out itself a particular description of human nature and claim. You may recall that portion of Roe versus Wade in which the Supreme Court had feigned to have no idea what this human-shaped figure in the womb might possibly be. Is it a human being meriting legal protection from murder? Dear me, said the court in Roe, these are depths too profound for us to plumb, since philosophers and theologians and scientists can't really figure out what this womb dweller is and what is owed to it. Certainly we, the justices of the Supreme Court, shouldn't pretend access to such esoteric insights. But notably, the court's feigned epistemic humility didn't translate to the court leaving in place the historic state legal protection for unborn life, but instead the court offered it as a reason for the unimpeded slaughter that has marked the last half century. And along the way, it wasn't just the child who was assassinated, but also the public truth and meaning of maternity and of family more broadly. In the Planned Parenthood versus Casey decision, this was the court's abortion ruling in 1992, the court extended its explanation from Roe for why abortion is a really good idea by now casting it in terms not just of a right to privacy, but highlighting women's equality and empowerment, which are honored by ensuring that they are not tied to the responsibilities of bearing and tending to children. Having a full-time career outside of the home is not easily concordant with care for children. We have come to learn from the Supreme Court and its case law, among other cultural sources, that the way to honor women is by classifying distinctly feminine features, such as the miraculous capacity to bear and nurture new life and the associated high calling to domestic superintendence and investment, as unworthy of admiration. These are instead impediments to a life well lived. Thus, women's legal prerogative to kill their unborn children is crucial for female empowerment. Empowerment on this model means to achieve approximately maleness in its social and workforce options. Masculinity represents legal and personal value. Femininity does not. So women, to achieve value and liberation, at least in the purportedly objective sense of the law's priorities, even if women would subjectively choose the contrary, they must be able to avail themselves of techniques that would suppress or eliminate features and manifestations of femininity. Thus do we read from the court's Casey decision the following, I quote, "The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives," end quote. As to the euphemism of controlling their reproductive lives, what the court is conveying here is that dead children compose the platform on which women stand in order to participate equally in the economic and social life of the nation. Evidently, the family is not part of the economic or social life of the nation on this account. So economic and social life must mean individuals as individuals, not as persons in indelible relation. Erica Bacchiacchi has observed about the Supreme Court's abortion jurisprudence and its ideological promotion that, she writes, easy abortion access has thus made it unnecessary for businesses and other institutions in the United States to acknowledge the essential cultural reality that most working persons are or ought to be deeply encumbered by their prior obligations to their families and to the dependent and vulnerable at large.
Yeah, I bet. Yeah, it gives you a little more time. Yeah.
Indeed, Justice Ginsburg in her dissent, I'm sorry, in the 2007 case of Gonzalez versus Carhart, reiterated the Casey court's ruling of kind of promoting the idea of women as unencumbered selves and economic units as a constitutional right status, elaborating its theme of female empowerment and attainment of a worthwhile life destiny through abortion access. Justice Ginsburg quoted the court's prior opinions in order to describe the connection of the view of women with the law's outcomes. She writes, there was a time not long ago when women were regarded as the center of home and family life, with attendants special responsibilities that precluded full and independent legal status under the Constitution. Those views, this court made clear in Casey, are no longer consistent with our understanding of the family, the individual, or the Constitution. Thus, legal challenges to undue restrictions on abortion procedures center on a woman's autonomy to determine her life's course and thus to enjoy equal citizenship stature. There ends the excerpt from Justice Ginsburg. So here again, we see this idea, decades enduring in the law, that killing of innocent children is a woman's legal prerogative, as it is the predicate to her autonomy and equal citizenship. In the lead up to the Supreme Court's Dobbs ruling in 2022, which happily overruled the Roe versus Wade ruling, a prominent part of the pro-Roe legal argument was that there is a legally relevant reliance by the community on the availability of legal abortion. And this should be a ground for the Supreme Court to uphold and reaffirm the Roe ruling. Michael Hanby has written that this reliance argument may be absurd as a matter of constitutional reasoning, but as an empirical and sociological observation, it seems, he writes, to me profoundly correct, indeed much more profoundly correct than the court in Dobbs realized. Our prevailing white-collar proletarianism, an ideal atomistic world populated by sexless, genderless, and childless pundits and programmers, depends as surely on abortion and contraception, being reliable social facts, as the cotton economy of the Old South depended on slave labor. One does not dismantle such peculiar institutions without overthrowing the reigning human archetypes, without upending an entire social structure, or without a fight, end quote. So half a century of legally enabled abortion access, all advertised as liberation, and then relied on in the design of our economic and social arrangements, has been internalized by incessant practice and constructed expectations into several generations of men and women. This is not a condition that's overcome merely with a court ruling. The several states, red or reddish states included, Missouri, Ohio, Montana, Arizona, and the like, that have adopted pro-abortion policy after the Dobbs ruling should tell us something about all of this social dynamic. Okay, next we'll take a glance at IVF. While the abortion death toll remains staggering, the number of embryos who each year through IVF are created and then die or are consigned to the freezer is about double the number of unborn children killed by abortion annually. The ethical question of IVF has been one mostly AWOL from discussion in the evangelical world until quite recently. The Catholic Church has long addressed it via encyclical in various iterations of its teaching ministry and sponsored academies. And among the community of Catholic scholars, there's been a comparative silence from the Protestant and evangelical side, but we hit a turning point last year. In February of 2024, the Alabama Supreme Court ruled in the case of LePage versus Center for Reproductive Medicine, which involved a controversy over an IVF matter that provoked a national turn in attention toward that question. The matter has been picking up steam in prominent discussion since then in various contexts. The Alabama Supreme Court's LePage case presented the question of whether the state of Alabama's wrongful death statute, which authorizes parents to bring a lawsuit against a culpable party for the death of their child, also authorizes a lawsuit by IVF customers against the IVF clinic when their embryos that they had paid the clinic to create and then maintain frozen in storage tanks at the clinic were destroyed due to negligence of the clinic and not protecting them from that destruction by an intruder. While I think the Alabama Supreme Court did not handle this precise question adequately, more relevant for present purposes is that what emerged in the court's ruling was the determination that frozen embryos are classified as unborn children under Alabama state law. Well, the response to this ruling was swift, hostile, and nationwide. If embryos are classified in law as persons and are treated as such, the IVF industry is done for. Persons, children are not the sort of thing that we put in freezers, let alone interminably, or dispose of when they're inconvenient or eugenically subpar, nor do we donate such persons for experimentation unto death. Yet this is exactly what the IVF business is all about and what it does every day. Estimates vary, but it has been concluded that only somewhere between 2.5% and 7% of embryos created ever reach live birth. The remainder, that is up to 97% of them, die in the process, are kept frozen, or are discarded. Accordingly, the legal threat to the IVF industry is plain if embryos are considered people rather than property. So the moguls of this multi-billion-dollar industry mobilized, and within about 3 weeks of the Alabama Supreme Court's ruling, the Republican-dominated Alabama state legislature rushed to enact a bill that immunized the IVF industry in the state from all liability for the deaths of those whom the Alabama Supreme Court had just identified as unborn children under state law. Under the terms of this new Alabama statute, the clinics who, through negligence or malice, are responsible for the deaths of embryos are immunized from all legal liability, civil or criminal. During the rush to enact the statute, a state representative had offered an amendment to the bill that immunity will not be provided to a person who intentionally causes the death of an unborn child. That amendment was voted down. Why? Because it would have nullified the whole purpose of the legislation, which was to perpetuate the IVF industry interests in the commerce of human life. As I mentioned, the discarding of embryos is a routine aspect of that business. This may be of interest to you. In Justice Mitchell's lead opinion in the the LePage case, he mentioned that all of the plaintiffs who brought the wrongful death civil action against the IVF clinic, there were 3 couples, had signed contracts with that clinic for the discarding or the destruction of their unused and unfit embryos. In any event, it was not just in Alabama, but in state houses across the country that Republicans scrambled to put on record their full-throated support of IVF. It was an election year, after all. At the federal level, all 49 Republican U.S. senators signed a letter declaring their support for IVF. Then candidate Trump made his support for IVF a prominent campaign issue, which he followed up on after his return to office with an executive order promoting subsidies for the industry. Texas Senator Cruz, Alabama Senator Britt last year introduced their co-sponsored IVF Protection Act that, if it had been passed, would have withheld Medicaid funding from any state that prohibited IVF within its jurisdiction. So much for the support of federalism and the historic state prerogative to regulate moral conditions within their jurisdictions. Now, I highlight the machinations emerging after the Alabama Supreme Court's ruling that implied a threat to this plainly third-rail political issue, simply to demonstrate the nationwide high priority status enjoyed by this industry of making and killing embryos, which plainly has behind it in the political class an enthusiastic enablement and support, and this coming from both sides of the aisle. Before moving on from this subject, a brief word, if I may, on the ethical scandal of the legally unregulated freezing of embryonic children, holding batches of them in suspended animation, available for later thaw if their use is of interest to the commissioning clients. For those of you who are inclined to look at this, the Congregation for the Doctrine of the Faith, or since its name changed a few years ago, the Dicastery for the Doctrine of the Faith in the Roman Catholic Church, has addressed cryopreservation in the document Dignitatis Personae. My quick point now, though, in view of our discussion on life and death, is simply that I'm uncomfortable with the customary blasé description of these embryos as being kept alive in frozen storage. I find this description problematic and misleading. The condition of cryogenically frozen embryos is a sui generis status. There's nothing else like it in human history or experience. It is not death, at least most of the time, but likewise, it is not life. And the very fact that the binary of life or death is not readily applicable to the condition of these frozen human embryos speaks to the enormity implicated in the condition that the industry foists upon millions of embryos now resident in nitrogen freezers, by which an inorganic condition of halt is imposed upon them. This unnatural status is achieved by freezing the embryo in an anhydrous chemical solution, fundamentally disintegrating, thus imprisoning the child in a non-dynamic, inorganic, inert status. These small children are not only made by technicians in a lab and stored far from womb and home. Of course, they're enclosed in a storage canister, but they're also separated from a condition of organic integrity, being kept in suspended animation, locked in an inorganic limbo, and denied a natural life course. Leon Kass has written that, I quote him, "We are witnessing the erosion, perhaps the final erosion, of the idea of man as something splendid or divine, and its replacement with a view that sees man, no less than nature, as simply more raw material for manipulation and homogenization. Hence our peculiar moral crisis. We adhere more and more to a view of nature and of man, which gives us enormous power, and at the same time denies all possibility of standards to guide its use." End quote. That said, next let's jump to the novel concept in medicine and law of brain death, or the neurological criterion of death, as it's also called. But first, a look at the historic and traditional definition of death. This from Webster's 1828 dictionary. entry for death. That state of being, animal or vegetable, but more particularly of an animal, in which there is a total and permanent cessation of all of the vital functions, when the organs have not only ceased to act, but have lost the susceptibility of renewed actions. Thus, the cessation of respiration and circulation in an animal may not be death, for during hibernation, some animals become entirely torpid, and some animals and vegetables may be subjected to a fixed state by frost, but being capable of revived activity, they are not dead. The Webster's 1953 version has more or less the same beginning: total and permanent cessation of all vital functions. But in 1968, a Harvard commission stipulated that cessation of measurable brain activity should be the standard of death, with various test methods proposed to diagnose that condition. But we might ask, why at this late hour in human existence need we replace the intuitive and universal recognition of death as cardiopulmonary expiration, with which there's no absolutely certain moment of departure from life, and come up instead with a new medical standard for classifying a human being as dead? Why is this? Well, the change was not a disinterested one. It arose during a time in which also in refinement was the practice of surgically removing organs from some persons for transplant into another. The brain death standard provided grounds to legally facilitate that practice by classifying the organ donor as dead, even when he is very much alive by the traditional understanding of that status. Nearly all states had then, by that point in time, passed the Uniform Anatomical Gift Act, this being at the time that the Harvard ad hoc committee had issued its 1968 alternative definition of death as cessation of brain function. So the question presents, as my son, who just wrote a paper on this issue, put it, is the person on the hospital bed who is declared brain dead, yet while on a ventilator continues breathing, digesting food, excreting waste, fighting infection, healing wounds, in fact dead? How about when the person is a woman and is also gestating a baby until it is delivered at full term? Is she dead? Can a corpse do all of these things? On the brain death account of things, yes. You can find reports of brain dead classified patients grabbing nurses, manifesting spikes in their blood pressure and cardiac activity when the transplant team's surgical instruments cut into them. And this explains the practice of sedating and anesthetizing the so-called brain dead donors. But what if the patient is not dead? The harvesting of organs from that living, breathing body would be an act of what? Well, of killing, thus violating the dead donor rule. So you see why the question of when a person is dead down to a particular moment suddenly has become a matter of momentous consequence, one having an urgency never before present. In the old days, we had no interest in discussing the precise moment of death, but now there is an industry desiring access to bodies to harvest perfused organs, whose utility as transplant organs disappears with the passage of time after cardiopulmonary expiration. If the asserted definition of death as brain death is eliminated, the collection industry that now exists would be done away with. This figure is from about a decade ago, but at that time, over 90% of all donated organs came from patients whose bodies are kept alive by artificial measures. Until recently, 100% of heart transplants came from those classified as brain dead, as the particular sensitivity of the heart is such that it is least transplantable of all the organs unless fetched from a living organ perfusing body. But more recently, with the development of certain perfusion methods, heart transplants harvested from the so-called brain dead has dropped down to only 90% of the total due to the use of controlled organ donation after circulatory death, which is another category which has its own series of ethical concerns. So I'll turn to that very briefly. The protocol for controlled donation after circulatory death likewise is driven by an aspiration to acquire more organs for transplantation, meaning that the protocol is designed in a way to resolve the person dead within a small window of time that permits quick death resolution, and also one that allows access to the organs before ischemic damage, from lack of blood flow and oxygenation. The standards require at least 2 minutes after the last heartbeat before sawing open the sternum and restarting the heart, or use of mechanical circulation in the body, or both. Though notably, the process involves clamping off the heart's blood flow to the brain. Thus, in effect, as the American Society of Anesthesiologists has put it, converting the circulatory death donor into a brain death donor. As again, while the vital organs are returned to life, the brain is being starved of blood flow. And with patient consent, the setup for all of this process can be and is arranged while the person is still on the ventilator and very much alive, even on contemporary metrics. In any event, Hans Jonas protests all of this sort of thing, writing, when only permanent coma can be gained with the artificial sustaining of functions, by all means, turn off the respirator and let the patient die. But let him die all the way. Do not instead arrest the process and start using him as a mine. Back to brain death. Because you are all theologians in training, I thought I'd mention that Michael Vaca has offered the argument in an article in the Lineker Quarterly that the brain death criterion is grounded in a heretical view of anthropology, as set forth by the Council of Vienne that had met in years 1311 and 1312. The council's statement was that it is heresy to assert stubbornly that the rational or intellectual soul is not the form of the human body itself. This teaching being derived from Aquinas, that the soul is not localized in a part of the body, but instead infuses its entirety. The relevance of this is that the brain death proposal rests on the notion that the brain is the single integrating organ of bodily life of the human organism, about which a few observations. As Vaca says, since the soul is not localized in the brain, the non-functioning of the brain does not provide sufficient evidence that the soul is no longer present, particularly when there are manifest biological signs of life. Indeed, the only adequate explanation for the biological life of those declared brain dead is not a ventilator, but rather the continued ensoulment of the body. Also, just as an empirical matter, as neurologist Dr. Alan Schumann writes, the integrative unity of a complex organism is an inherently non-localizable, holistic feature involving the mutual interaction among all the parts. Indeed, the evidence is by now plain that significant integrative capacities remain for those diagnosed as having total brain failure. And there are yet more practical problems with the brain death proposal. One is that the diagnosis, even on its own terms, is unreliable. Many are the reports of persons who have been designated as brain dead, who have then shown themselves to be very much alive, including some people now walking around among us, raising families and the like, all rather reliable signs of not being dead. Professor Irene Alexander has pointed to Dr. Schumann's meta-analysis of 175 cases of brain dead classified patients who showed signs of integrative capacity such as detoxification and elimination, temperature regulation, febrile responses to infections, sexual maturation and proportional growth. Speaking of which, one famous case of misdiagnosis involved one Jahi McGrath, a young girl independently diagnosed as brain dead by 3 separate neurologists, but who thereafter began menstruating and manifesting breast enlargement. Menstruation requires a functional pituitary gland, of course, thus indicating brain function. Professor Alexander has also emphasized the problem of brain death proponents presented by the everyone agrees to be alive patients with high spinal cord transaction. Due to the spinal cord injury, the brain cannot integrate with the body below the head. Thus, it is by the external contribution of a ventilator that the spinal cord injured person stays alive. Why is that person alive, but the other ventilated person who is breathing, digesting, excreting, and so on is not? Consciousness is the difference between them, but we don't, for instance, identify comatose patients as dead because they're not exhibiting signs of consciousness, you see. Well, enough on that issue. There's obviously a lot more that could be explored there if you're inclined to do so. And of course, there's more we could discuss on the bioethics side of things in the law. For instance, you might recall the litigation over the Obamacare contraception mandate, several challenges over which went to the US Supreme Court on religious liberty grounds. In the Hobby Lobby case, you might remember that corporation had challenged the regulatory requirement under the misnamed Affordable Care Act that it provide forms of contraception with abortifacient effects. There are numbers of cases around the country of similar sorts of claim. The death penalty, a quick touch, I'll just say, after the Supreme Court had first ruled the death penalty as it was applied in the states as unconstitutional, this was in 1972, it thereafter, 4 years later, ruled that, okay, it can be constitutional so long as there are in place a particular system or systems that provide for bifurcated proceedings and so on for assessing the circumstances of the matter and the like, the details of which aren't so important. But it just was clear suddenly that the court now was going to be regulating the entire field of the death penalty. Once it classified its own kind of prerogative to be instructing the states on the matter, the litigation in the field just flourished. For instance, the court has ruled in various cases that a mandatory death sentence is unconstitutional, that capital punishment statutes must provide for considerations of mitigating evidence and so forth. Age limitations are imposed on the imposition of the death penalty, mental capacity standards. It may only be applied for murder offenses, said the court, and so on. So a couple of case illustrations here. In the case of Roper versus Simmons, there was a 17-and-a-half-year-old defendant who had broken into a woman's home, tied her up, wrapped her face in duct tape, then took her to a railroad bridge and threw her off the side into the Merrimack River where she drowned. He had described to his friends his plan to do this before the fact, and afterwards he bragged to them about having done it. And in this case, the Supreme Court ruled it is unconstitutional to impose a capital sentence on him because he was 17 and a half, not 18. And the court said the Eighth Amendment's prohibition on cruel and unusual punishment, which the court interprets according to the, quote, evolving standards of decency that mark the progress of a maturing society, found that this sort of death penalty would be cruel and unusual. The court said the consensus, or at least the trajectory that it discerned, was that the juvenile death penalty is cruel and unusual, you see. So an example of what the court has dealt with or how it has resolved a question in this field. Another one, Kennedy versus Louisiana. I was actually present at the Supreme Court when this case was argued. The question presented in that case was whether the Supreme Court would interpret the Eighth Amendment's cruel and unusual punishment prohibition to permit or to forbid Louisiana to impose the death penalty on a man who had violently raped his 8-year-old stepdaughter. The court had earlier ruled that states can't apply the death penalty to an adult or to a defendant who had raped an adult victim. So the question in this case was, does that rule apply also to child victims? And the court announced, yes, it had discerned and evolved national consensus against the death penalty for this sort of thing. So the court ruled this also to be unconstitutional. This hasn't sat well with everyone. Recently, Florida and Tennessee enacted statutes providing for the death penalty for the rape of a young child, and this being by means of a challenge to the Supreme Court's ruling in the Kennedy case. I understand the Alabama House has recently passed a bill of this sort, now waiting action by the Senate in that state. So anyway, I don't know if I'm running out of time. I'll just say very quickly, there are some other issues pertaining to the body after death that the law engages with, such as the ubiquitous state laws criminalizing the abuse of a corpse, which suggests something about the law's perspective, at least historically, on the significance of the human body even after death. The history of burial in Christian societies that rejected the pagan practice of burning their dead has obviously had a notable reversal. The Jacobins in late 18th century revolutionary France inaugurated cremation for the first time in 1,000 years, legalizing that practice in 1795 as part of its focused overthrow of a Christian social order. Cremation was legalized in Britain at the end of the 19th century, though not catching on for decades. It is now the substantial majority practice there. I think it's over 70%. In the US last year, cremation was over 60% and trending upward. All of this being a remarkable turn from Christian practice through the centuries, and of course, with the law's participation in it all along the way. So I think we'll tie things off there. I'll spare you further suffering at my presentation. Obviously, I didn't offer my commentary as any kind of a comprehensive or even adequate explanation of the issues that I raised, but rather I just wanted to flag a number of issues for those of you who may find these matters of interest and otherwise perhaps to pursue later in your abundant free time. So thank you for your kind attention.
Well, thank you very much for flagging those significant matters for our attention. As we move into a few moments of Q&A, I'm going to lead off with what I hope to be a restatement of maybe the connecting thread as you place the question death of the law within the title. From what you've said, is the death of the law that you're seeing the function of the disappearance of these transcendentals or principles or grounding concepts, such that the confusion that arises over what is a woman, what is life, what is death, the disappearance of those fundamental concepts seems to open up the law to consistently remove any barriers, simply basically taking their hands off at that point. We don't know what life is, so we can't forbid this or that practice. That seemed to be a running thread to me. Would that be a fair way of, one way of articulating the death of the law?
Yes, yeah, I think that's right. When the law itself can't, when it mucks up the questions of life itself, one can wonder, where does the authority of the law come from at all? I mean, the law is oriented to, it's directed to human beings. What is a person? And to the extent that the law is either unwilling or incapable of addressing an answer to that question, we could say the law itself maybe has perished along with that.
Thank you. Other questions, you can raise your hand or drop a question in the chat. We'll keep note of that.
I have a question.
Go ahead.
If the law itself, the mechanism itself for regulating these sorts of things is hopelessly corrupt at the core, then how ought we to address ourselves in the legal and political sphere to right these wrongs, or what should we do?
I would not want to say it's hopelessly corrupt. While it's corrupted and corrupted in many of its aspects, there is a great deal that yet remains that is alive and reasonably well. One of the reasons I wanted to emphasize our long history, you know, when I was talking about the euthanasia question in the Glucksberg case, was the court was looking back at the last 700 years of our legal tradition. And, you know, there is something of a salutary development going on in Supreme Court jurisprudence at the moment. Not only do we have a much better court than we've had in decades, but the kinds of emphases that the court is offering is toward looking in the direction of our traditions, our history, and the like. So even though there remains something of a strangling off of the theological input, there is, we might say, the connection to that theology by virtue of going through our history, which was more explicitly based on this kind of comprehensive understanding of the world we inhabit and a development of law in keeping with it. So we have a lot of historical material that continues to be resident in our law. And as a result of that, I think there is a great deal of material for us to be working with as we are aiming in the direction of progress. So I highlighted a number of very problematic areas of the law, but I don't think they're beyond remediation. Obviously, there's a great deal of work that needs to go. Like anything valuable, I suppose it's worth the sustained effort to get it done. So I again, just in case I didn't mean to depress everyone, but rather to kind of motivate a kind of energetic response to these unseemly developments in the law. And I do think there's room for improvement, certainly with a community of committed individuals that participate in this process of rescue, we might say. There's hope farther down the road. I don't know how long down the road, but I think it can be done, Lord willing.
You mentioned the more favorable, responsible Supreme Court. Are there groups on the other end appealing to on a number of these fronts? Is there a sense of motivation more broadly? I'm rephrasing Derek's question from the chat.
Is there a sense? I'm sorry, could you maybe rephrase it one more time for me?
Well, Derek said, are there groups advocating for legislation to reverse these trends? And I should have just read what he put in the chat.
Yeah, I think so. There's, and I guess it would depend on which particular thing. I think I'm nearly despairing of the, when I was speaking of the Deep South Republican Alabama legislature that's going all in on this IVF business. It's like, dear me, I mean, it seems like we may be quite some distance from a turnaround on that question. There's a lot of work that needs to be done, I think. But, and this was one of the reasons I mentioned the fact that on this side of the Tiber, we've been essentially silent on those questions. And that, of course, has contributed, I think, to great extent to our political condition. So the church has a responsibility to be teaching more clearly on these matters. But as I say, there is something of a revived discussion that's taking place now as a result of that Alabama decision. So I think we really have a number of avenues available to us to be talking through and working on these matters. I know that in lots of places, there's political activity in the works aiming to be trying to restore sanity in some of these areas. Thankfully, we've got family policy councils around the country that are devoted precisely to these kinds of questions. So that work is being done. May the Lord bless it.
Dr. Atwood has a question.
Yes, thank you, Jeff. That was terrific, as always, delightfully clear and helpful. The one question I have is actually spawned from my recent attempt to renew my license, my driver's license, because on that they ask, do you want to be a donor? And this is something that virtually every driver, I think, today is faced with. And the issues you raised with what constitutes death and being an organ donor in the case of an accident raises the question of, is it a wise thing to say, sure, I'll be a donor, thinking generously about giving oneself away for others, but at the same time, perhaps putting yourself in the position of being murdered in order to harvest your organs. So as you've thought about that, how do you advise someone on that question of, should I say yes or no on a donor decision?
Well, my advice is always that you say no. That probably won't surprise you to hear me say that in view of my comments earlier. One of the remarkable things about this whole donor registration system is that the decision is imposed upon a person in of all places, the DMV office. The idea that there's any kind of genuine informed consent being given, because when you're going in to the DMV to get your driver's license renewed or what have you, in the company of probably lots of people all around and so forth. And the lady behind the desk has no idea what she's asking you. And you have no idea what you're answering when you say, yes, yes, make me a donor. Of course, you haven't had explained to you that you're going to be alive, likely, when this is being done to you and so forth, is not explained to anyone. I mean, there is no legitimate informed consent in that context. So, I mean, I'll just tell you as an anecdote from my personal experience, when I was asked that question recently, I shouted out no, and probably startled the lady, not just because of the answer I gave, but in the way that I gave it, but it's always kind of disturbing to me as I watch that question be registered and people kind of answer drolly, yeah, sure, having no idea what it is they're being asked or what they're answering.
A somewhat related question in terms of responding at the lay level. Sammy mentions in the chat they had friends who adopted an embryo from IVF. I'm guessing here he means not their own pursuit of IVF, but as a strategy to mitigate the harm of IVF. What's a Christian response? Is that an appropriate practice, a means of redress?
I don't think it is, but that actually probably calls for a whole other presentation. I mean, that is a long discussion, but I think I would just say, I'm kind of wrestling with myself right now. Do I even start to offer an explanation for that answer? No, I think that the womb is not a mechanism. It is an aspect of the relational dimension of a woman in a marital relationship. She should be impregnated by her husband in the conjugal act and no other way at all. And no one should be participating in this system. But really, for me to give an adequate answer to that question requires something like an hour, not just a quick response. So I'll just flag it and say someone can follow up with me later if they want further detail on that. It is an ethical contest, obviously. There's a lot of discussion taking place on that.
This idea of, speaking of abortion or policy or strategy, this idea of contrasting immediatism versus incrementalism continues to come up, and I hear people debate about it. A couple of things, what do you think about those two systems in and of themselves? But beyond that, given that you've demonstrated how many definitions and points of consensus we've lost as a culture, is it even useful to frame a debate between those two strategies? I mean, is that even a fruitful thing to do?
Yeah, I mean, I would want to say that there's something important about a public statement that human life is something that ought not be negotiated, that life is precious in all of its dimensions. And so when we're thinking in terms of the abortion debate, of course, the only way to proceed in the ideal condition is to protect that life. We're not in a condition where that can be accomplished. And, there has been a great deal of progress because of something of a progressive, incremental effort in a particular direction. So the Dobbs outcome, I think, was very important for a number of reasons, but it was the result of something of an incremental move in the direction of life. This, I understand, is very contested ground. My own position is I have an appreciation for we might say, the declarations that come from the absolute community. But I'm also very appreciative of the incremental approach that I think is well suited to the condition that we now find ourselves in.
And so as we consider the pastoral role in considering and responding to these concerns, what strikes me is that a key aspect of what a pastor can do is to simply provide biblically informed, but also natural law, common law informed definitions of these key concepts and ideas that have been missing: life, death, person, man, woman, baby, justice, nature, human being, soul. These are words we use a lot in preaching and in counseling, but it seems to be that there's a disconnect between people's responses. Well, you've mentioned the evangelical ignoring and ignorance of the debate surrounding IVF. If we knew what we were talking about, it seems like eyes would be opened. And that seems to be a key place where pastors have something they can do immediately, practically, in terms of providing these definitions of these key terms that we think we know what they mean. Now, the second strategy that I would think pastors could respond to would be to call Christians to an embrace of suffering as a part of the Christian vocation in a medical context that promises quick relief through unethical means. I'm thinking of infertility, organ transplants, immunizations developed through fetal tissue from abortions. These types of questions promise a relief of suffering, which is why they have cachet for Christians, which is why we would want to participate in them, because alleviating suffering in the abstract is a good thing. But when we lose sight of the fact that sometimes God calls us to suffering, we can open the door to these unethical considerations with a new pressure. So my question then is, what's a good way for pastors to become better equipped on the common law front? Where do we go to find these definitions? You referenced the older editions of Webster's dictionary, but do you have other resources, other places for us to get up to speed on typical common law concepts and constructs?
Yeah, that's a good question. Obviously, what I was doing was aiming to skate across a whole bunch of different issues. And so I suppose the answer to your question would be associated with which of those particular matters. I do think, I was having a conversation with someone recently about this, that with respect to matters of bioethics, we ought not think of the Roman Catholics encyclicals and other forms of instruction and academic work as being a denominational position, but it really is a Christian one, in the sense of it's thinking of what did God intend by the created order. And so our own silence, I think, can be compensated for by looking in the direction of some of that work that's been done. So there's nothing non-Protestant about going to, look into matters of cryopreservation or IVF or some of these other bioethical questions simply by looking at the material that's been very carefully put together by those scholars and, the dicastery and the like. So I think that's a good source for some of those kinds of questions. And then derivative of that is a massive literature that's further elaborating its terms, and both in empirical aspects as well as philosophical and theological and so forth. So there's a mountain of stuff out there that can be looked into. When we're looking at questions of kind of euthanasia and the like, likewise, I think there's a fair amount of readily accessible, kind of carefully thought out assessment of these kinds of issues. There's an organization in Canada called Cardis that does really nice work on this question. So those, if that ended up being an emphasis of, some pastoral work, there's a lot there, So I don't think that any of the stuff is especially elusive. I think on balance, the internet is maybe not a net positive, but it certainly makes research a lot easier. And so there's a lot out there that's I think accessible. And I would just say, if somebody really needs some help in finding out answers to particular things or how the discourse is proceeding, but by all means, I would make myself available to assist in that respect. So.
Well, thank you for that. And thank you for your presentation today. With just a few minutes remaining, we're going to go ahead and turn to hopefully resetting hearts and minds through a rendition of The Day as Past and Gone. And then we'll conclude with a few brief announcements and our closing prayer. So let's turn to that.
past and gone, the evening shade draw near. Oh, may we all read, night of death draws, night of death draws, may we all read, the night of death draws near. We lay our garments by upon our beds to rest, so death will soon disrobe we hear, so what we hear, so death will soon disrobe all of what we hear possess. Lord, keep us safe this night, secure from all our fears. May angels guard us while we sleep, morning light up. May angels guard us, morning light us till we sleep, till morning light appears. And when we early rise and view the unwearied sun, may we set out to rise and after rising, after glory, may we set out to rise and after glory run. And when our days are past and we from time remove, oh, may we in thy bosom rest, thy bosom of thy love. May we in thy bosom rest, the bosom of thy love.
All right, a couple of brief announcements. We are on summer break for Cappella. We'll resume in the fall, and hopefully we'll see many of you at our Refresh Retreat, June 25th through 28th. Signups are open for summer classes. Hopefully you've already signed up to take the various classes that are being offered. We look forward to seeing you for that intensive term, and then we will see you again for Cappella in the fall. As we close today, I've asked Andrew Harris to read our closing prayer. So Andrew, if you will read for us now.
Dear Lord, in the midst of life we are in death. To whom may we look for help but from you, Lord, who for our sins are justly displeased? Yet, Lord God most holy, Lord most mighty, holy and most merciful Savior, deliver us not into the bitter pains of eternal death. Amen.
Amen. Thank you, Andrew. Special thanks to Jeff Shafer and to all of you for joining us today. Go in the grace of the Lord Jesus Christ as you look forward to worshiping with his people tomorrow. Thank you all.
Thank you, Jeff. It's very good. Much appreciated.
Thank you, Jeff. That was very good.
Welcome. Thanks.